everyone, and welcome to our show. Today, we're going to be talking about pre-existing conditions and long-term disability claims, and what exactly that term means in the context of a long-term disability claim.
You're watching Your Disability Lawyers with David Share and Samantha Share. Contact Share Lawyers today for a free consultation. There are no fees unless you win your case.
I think there's a lot of confusion about pre-existing conditions because in general layman's terms, a pre-existing condition means a condition that you have prior to making a claim. At least that's how I would define it. But that's a bit of a misconception because when you're making an application for long-term disability, pre-existing condition has a very specific definition and really only applies in very specific circumstances. So David, can you tell us a little bit more about that?
Yeah, for sure. Hi, everyone. You've probably heard things about pre-existing conditions. If you've ever taken out travel insurance, it might say something like, if you have any of these problems beforehand, we're not going to cover you if you travel out of country. But when it comes to particularly group disability policy, something you would get through your workplace, it usually only applies in the first year after you have secured coverage. So let's say you start working on January 1st and it takes 90 days for your coverage to kick in. The pre-existing condition clause would usually run from that effective date after those 90 days and be looked at for the following year. So if you put in a claim for disability, they will look at how you fill out your medical form, and they will likely send you a letter if you make an application saying, because you made this claim within the first 12 months of coverage, we must look at your prior medical history to see if you were getting active treatment for the condition that is now disabling you, usually in the 90 days prior to your claim. And it's complex, but the bottom line is that it usually applies in that first year of coverage. And it's important for people in this day and age where there's a lot of portability of employment, people moving from one job to the next, not thinking so much about benefit coverage and what happens with that. But every time you move, it resets the clock on that pre-existing exclusion. So if you have a medical history and are worried about being covered for disability in the event that you have to make a claim, you need to be aware of the fact that this pre-existing condition exclusion may completely bar your claim for long-term disability benefits.
Yeah, and the issue with the pre-existing condition clause is if the insurer is successful in arguing that you have a pre-existing condition that meets their definition under the policy, and it does vary between insurance companies, but David gave a general explanation as to generally how that's applied. It's not just a medical condition that you're treated for. It could be that you're taking medication or that you've seen a doctor for the same condition for which you're now claiming disability during that pre-existing condition period. So they will look more extensively at, for example, your prescription summary, any doctors that you've seen during that period of time, and examine things in great detail. And if the insurer is successful in stating, well, we're not going to pay your claim because you have a pre-existing condition, it's a coverage issue, meaning you therefore do not have coverage and they don't have to pay you anything, which is different than a lot of other types of cases that we handle where there's a denial of disability because they do not meet the test for total disability under the policy, which is a little bit more of a gray area as to, does your medical yes, we believe you have a medical condition, but we don't believe your medical condition prevents you from working, is often what the insurer might say in a more typical denial. But with pre-ex, it's a coverage issue. So if you don't have coverage, you don't get any money. And so therefore, if we were to consider a case where somebody had been denied on the pre-ex, we're going to want, Share lawyers would want to review everything that the insurance company looked at in terms of the medical and maybe more, and to determine whether we think there's a case to, or an argument to be made that the client did not fall under this exclusion, and we want to be pretty sure that there is an argument to be made, because we don't want to take on the case and then it becomes a big waste of everyone's time.
So, in order to help, make this a little more understandable for you, we're going to talk to you about an actual case in a little bit, so that you can see how things worked out in that person's particular case, and you may be able to more easily see how it may apply to you and in a situation that you may be dealing with. Because when we talk about all of these different clauses and things, it probably makes your head spin. And how am I ever going to understand any of that? So we're going to try and break it down a little bit for you.
I am Adam Parry, and I'm an intake representative, and effectively my role here is to speak to clients who are contacting the firm for legal advice in relation to their denial or termination of disability benefits. Our role is limited to discussing cases with new clients, so that is what we are doing day in, day out. We're very experienced in that respect. We're very used to speaking to clients who find themselves in difficult situations because of a denial or termination of disability benefits, and therefore we're able to give them the best support and the best guidance for going forwards. Pre-existing exclusion clause denials are difficult. To be honest with you, we're certainly speaking to clients a lot at the moment who have been denied due to pre-existing clauses. I think one of the difficult things for clients receiving a denial letter from an insurance company for a pre-ex clause is that the insurance companies do a very good job at sounding very convincing in their letters. They list all of these medical records and medical documents that they've reviewed, and then they set out all of the reasons why they, the insurance company, think that the client is not entitled to disability benefits. And I think when clients see that kind of denial letter and have it all there in black and white, they feel extremely stressed and, to be honest with you, quite defeated as well. Because we have to remember, these denial letters often don't come out of the blue. They are a culmination of several weeks or several months worth of correspondence and calls between the client and the insurance company or the case manager. And I think for the client to have gone through getting all of that information, getting all of that documentation, submitting it to the insurance company, and then sort of getting knocked to the ground at the end by getting that denial letter is very difficult to accept. I think the next steps are to speak to us so that we can get the full picture, so that we can get the full story. Insurance companies are very good at interpreting things in a way which suits them, and I know that can be distressing to see, and I know that can make you feel very anxious and very scared. But we know when we look at these denial letters that this is not the full story, this is not the full picture. So speak to us, let us hear the full story. We want to hear it right from the beginning. How did we get to this point? What is the truth behind the matter, so that we can guide you and give you the right support going forwards. So one of the things that I've been noticing, and I think it's been particularly bad over the past couple of years with COVID, but I think also just in relation to the state of the healthcare system generally, is that a lot of clients are struggling to speak to or to see the physicians or the specialists that they need to be seeing. And that is concerning for a couple of reasons. Number one, the insurance companies will often take advantage of that to argue that the client is not receiving the right medical treatment or getting the right advice in relation to their condition and symptoms. but also for the client's own peace of mind. Often they don't have a formal diagnosis. They want to know what's going on, they want to know what's wrong with them, and they want to know how long it is going to take them to get better. So one thing we do to help our clients overcome that is we sign all of our new clients, and indeed their family members, up to something called Maple. And Maple is a virtual healthcare platform whereby a client can request to speak with a doctor or another physician, and they can talk to that physician about their symptoms, they can get medication refilled, and they can also seek referrals to specialists. So it's just another tool we offer to our clients to help them, to support them, and try and take some of the stress and strain away from what they're dealing with.
So we're going to give you an example of a client that we had. Her name was Cindy. And Cindy had a medical condition. She had chronic pain, and I believe she had been diagnosed with fibromyalgia. And she'd been working for many years with this condition. And she was on a medication that helped her to manage her pain. And the medication was the type of medication that helped with pain, but it also sometimes was prescribed for mental health type conditions like depression or anxiety. Cindy didn't know that, of course. She was just taking this medication to help manage her pain. She at some point decided to change jobs. And the new job that she got was a more stressful, high stress type of job. And when she started working, initially it was okay. She wound up, satisfying the 3-month waiting period to get coverage. She got her group benefits, and she was doing okay. She continued to manage, and as time went on, her work became more and more stressful, and I think that work environment really triggered a bit of a mental health breakdown for Cindy. She went to see her doctor, and her doctor, I believe, diagnosed her with depression and anxiety and put her off work. She then made a claim for short-term disability benefits under the group policy, which was approved based on the mental health conditions she was suffering from. She then, after the short-term disability claim period was over, she was then transitioned to long-term disability with the same insurance company. But because of the timing of her claim, that the fact that she had gone off work less than a year after she got coverage under that insurance policy, the insurer was obliged to do what we mentioned, which is a pre-existing condition investigation. So they requested medical records from the relevant period of time, which would have been the 3 months prior to her getting coverage. So actually the first 3 months that she was working in this new job. And they looked at her prescription summaries, and they saw that she had been on that medication that I mentioned before, that was for her fibromyalgia, but can also be used for mental health. And on the basis that she was taking that medication during the 3-month period, they denied her claim, stating she had a pre-existing condition, that she was taking medication for the same condition that was now preventing her from working. At that time, Cindy called Share Lawyers and had a consultation with one of our lawyers, and discussed all of these details with us, and we then took on her case to fight against the denial of her benefits. David, do you want to tell us what happened after Share Lawyers took on Cindy's case?
Well, sure. I mean, so you may be wondering, obviously, how could we help, and it's how do you overcome that? And the short answer is you may not completely overcome the pre-existing exclusion when the case goes forward, and most of these cases end up being settled through mediation or a settlement meeting. there's usually some degree of compromise required. The insurance company isn't necessarily going to throw in the towel and say, okay, now we get it, and we're going to just pay. That can happen, and sometimes it is as simple as clarifying the medical, getting an independent expert to help sort of bridge the gap or get over the hump in terms of the difficulty in whether or not there was a pre-existing condition. But for instance, the clause in Cindy's case had the wording, directly or indirectly caused by a pre-existing condition. And so it's possible to say that when you're suffering from chronic pain and fibromyalgia and you're prescribed a medication that is very often used for mental health claims, she may have suffered with some mental health issues as a result of her fibromyalgia and chronic pain. What was going on now in a new position is something happened in her life. There was a lot of workplace stress. There was some problems in her family. An elder parent was not well. She was dealing with a lot of stuff that was different from what was going on when she was working with chronic pain in the past. So we turned the situation where she was going to maybe only be able to rely on government assistance with nothing that would pay anything close to what her pre-disability income was, to getting something that would help her get treatment that she needed and hopefully get back to work at some point in the future without facing all sorts of financial difficulties in the meantime.
Yeah, and David, I think in fact in Cindy's case, I did follow up with her more recently, and I heard that she did go back to work. She was so happy with her settlement. It allowed her to get some treatment and some psychiatric treatment to help her to get through that hurdle of the stressful personal situation that she was in and the triggers. And she did find a new job that I think was less stressful and allowed her to manage her pain. So hopefully she'll be successful in that and not require our services in the future.
I think it's also important to stress that sometimes when people reach out to us where they've had a pre-existing condition denial, and we'll look into it further. And we may sometimes come back and say, you know what, this is not something we're going to be able to help you with. We're prepared to spend the time to review it and give you an honest assessment. We don't want to drag you through an extended legal process if we don't think there's any reasonable chance of success. We're prepared to put time and energy into that to make that determination, but our years of experience allow us to be able to come back to you and say, look, this is a case we think we can get some traction on and be able to do something with, or in some cases we're not going to be able to, but you can rest assured if we come back to you on that basis, and we've told you that we're not going to charge you anything unless we recover money for you, and you have our assurance on that. But it is important and makes sense to look into these things and allow a lawyer to review it and see if you have a chance. Another thing that's important, we tend to focus on people who are making claims, but there's a lot of people out there who are wondering, about benefits and what I should be looking out for. It's important for everyone in the general workforce because 20% of Canadians are likely to have a disability claim at some point in their career. And of those, and particularly because of the portability of workplaces in our current economy, people are going to be moving around, and the packages they have, the disability benefits and health benefit packages, are generally not portable, even unless you move within one company division to another where the same benefit coverage is in place. For instance, if you work in the federal government, it's very likely that you're going to have the same coverage from one department to the next. But that's not true if you move from company A and move across the street to company B. If they have benefits, it's a different package. So you're resetting the clock, and you need to understand that if you are struggling with some sort of health problem, and even though you haven't been on disability but feel like at some point, this is going to be a factor for me in continuing, every time you move around, you're resetting the clock. And if the timing doesn't work in your favor, then you may be stuck with a pre-existing condition. The other thing that's important to bear in mind is if you are somehow struggling and you've been at a company for a few months and you have some sort of pre-existing medical condition, keep in mind the time frame that you need to keep working through. Just drag yourself to work, try and get past that 1 year anniversary of your coverage so that they can't raise the pre-existing exclusion if you do. So read your booklet. If you're thinking of putting in a claim and you know you're within that 1 year period of when your coverage began, read your booklet before you put in the claim. Once you've put in the claim, it's going to be pretty difficult to turn back the clock and say, oops, no, my disability was actually 3 months later. I really was okay earlier on. I didn't really mean to make a claim. That's going to be difficult to unravel that. So obviously, certain medical conditions are not going to allow you to have that choice. But if you're sort of struggling along and wondering, can I carry on? My doctor says maybe I should take some time off. Try and keep going at it if you can to get past that 1 year period.
On the flip side, if you're considering moving to a new job and you have a medical condition, really think seriously about whether the timing is right to take on that new job, because if you have some other personal things going on in your life, and particularly when we're dealing with mental health, I would say, because it's so unpredictable. Just be cautious, because, starting a new job, having young children, having ailing parents, other family issues, those can all be triggers. And if you do that, all of those things, and you could have a real setback in terms of your own mental health, and then you're subjecting yourself to this pre-existing condition clause. Whereas if you had stayed in the old job and you've been there for a long time, then you won't have to deal with that issue. So certainly something to consider.
Yeah, no, that's definitely true and something to keep in mind.
You've been watching Your Disability Lawyers with David Share and Samantha Share. Contact Share Lawyers today for a free consultation and put our 35 years of experience to work for you. There are no fees unless you win your case.